I want to immediately resign, but my employer required me to work for 30 more days. What should I do?
This question has been asked time and time again, repeatedly, by clients, by friends, by strangers, no, who would like to ask me for a piece of my mind, no, kung ano ang masasagot dito. So, ang dami pong possible situation na kailangan yung employee ay mag-immediately resign, no, at hindi na niya kayang pagbigyan yung 30 days na turnover period na nire-request ng kanyang employer. Meron bang sinasabi ang labor code tungkol dito sa situation na ito? Meron po, no? There is. So, both employers and employees must be guided by this very important provision of the labor code that oftentimes hindi alam ng nakakarami, hindi alam ng management, hindi alam ng mga managers, mga business owners, executives. Article 300 of the renumbered labor code is our legal reference for these kinds of situation. Ito po ay about termination of employment when initiated by the employee. Two parts ito. Article 300 of the renumbered labor code has two parts, no? Part A and Part B. Doon po sa Part A, sinasabi po yung general rule na kung ang isang employee mag-resign ng wala namang kasalanan. Kumbaga wala namang ginagawang masama yung employer sa kanya, no? Ang tawag diyan, no just cause, no? There is no just cause for the resignation. Gusto lang ng employee na mag-resign for whatever reason. Because of health reason, personal reason, family reason. Ang tawag po diyan, resignation without just cause. Now, ano po ang sinasabi ng labor code? May obligation ang isang employee. Ang obligation niya ay to give 30 days advance written notice sa employer, no? So ito pong 30 days na ito, sometimes it's called the notice period, sometimes it's called the turnover period, sometimes it's called the render period, wherein the employee must render additional work for 30 calendar days, no? After lang noon, dun lang po siya pwedeng umalis, no? If the employee failed to provide such notice or comply with such 30-day notice, the employee can be held liable, no? Pwede siyang maging accountable. Bakit po? Kasi alam nyo, sa situation sa isang workplace, sa isang company, maraming activities yan, maraming deliverables, maraming commitments. So because of this, the labor code sees to it na may 30-day turnover period for the benefit, number one, of the employer, and number two, of the other employees, the co-employees, no? Kasi hindi biro po yan na matambakan ka ng trabaho. So, ano mangyayari dyan? Kailangan mag-overtime, kailangan humanap ng replacement, baka kailangan mag-train pa, baka kailangan mag-hire pa, no? Bago ka makapag-hire ng replacement, bago ka makapag-train ng replacement, no? It will take time. At paano kung andyan na yung deadline, no? It can be equivalent to a financial or economic or business sabotage, no? Kaya may ganyang provision po for the protection of the employer. Now, ang isang employer who was injured, harmed, prejudiced, inconvenienced in any way because of the immediate resignation of the employee, or kung hindi man immediate resignation, hindi tinupad ng employee yung 30-day requirement na yon, no, the employer can go against that employee. Pwede niyang i-hold yung employee liable and accountable for whatever harm, prejudice, damage, injury, loss, and whatever inconvenience that happened, no? Baka na-delay yung delivery, baka nagkaroon ng penalty, baka na-default si employer. So ito pong mga na-experience niya, mga penalty, mga interest, mga charges, mga overtime dahil kailangan niya magpa-overtime ng tao. Ito po, lahat pwede po yung computein ng isang employer. And then pwedeng i-charge sa employee at pwede yung i-offset do sa kanyang final pay, no? Napag-usapan natin in the previous episode. I hope you watch our previous episode because we talk about certain topics like final pay, no? So yung final pay nitong resigning employee, no? Kailangan i-compute 'yan. Of course, kailangan i-release 'yan, no? Meron tayong labor advisory regarding the release of final pay. It must be released within 30 days from the date of the severance of the employer-employee relationship. However, ito pong final pay computation, pwede pong ibangga dyan, pwedeng i-offset, no? Offsetting. Allowed po yan under the civil code when there are mutual claims against each other. Let's say the employee has a claim for final pay and the employer has claim for accountabilities dahil dito nga sa mga losses na and damages na suffer niya. No, pwede pong pagbanggain yan at kung anong diferensya niyan, yun lang ang i-release. Now, what if napakalaki nung damages and losses caused to the employer? Yung employee pa po ang may utang. No, yung employee pa ang kailangang magbayad at pwede po siyang kasuhan, pwede siyang mademanda. Depende po sa amount na kung magkano yung perhisyo na mapapatunayan ng employer laban sa kanya. So magkikita po sila sa korte. So yan po, no? That's part A. Now, ano naman yung part B? May part B. Part B is the exception to the general rule.